So today we're going to get into the MAR exclusive right to buyer agreement with consent to dual and designated agency. This is Form 714. We're going to get into what some of the changes are, how to present it, and how to fill it out. Let's get to it. All right, so the first thing we have here is that the buyer's going to put their names up on the top, right? So you have the buyer's name up top. Now, if you are working with an entity, remember, you can put the trust, you can put the entity, but we need the name of the executor who has the right to make decisions on behalf of that trust, right? So it should be care of, or whoever the person is, the executor. We need an actual name, not just the LLC, okay? Underneath that, they're going to grant to, and it's going to be the brokerage, not you as an agent, but the brokerage. So, in my case, it'll be eXp Realty LLC. Now, what I normally do is when I do eXp Realty LLC, I'll put a dash and I'll write my name. So it's eXp Realty LLC, but Luis Garcia is the agent that put this agreement together. Term of the agency, again, you decide with your buyer how long you want this to be, a few months, a year, whatever it is, put in whatever is appropriate. Any additional provisions or terms, if there's something unique about this or, provisions, add it there. All right, so number 2 is broker services. So this gets into what your duties are, how are you going to assist a buyer? It states you're going to make reasonable efforts to try to help them find a property. You're going to help them negotiate. You will help them, arrange showings and all that good stuff. So this is a nice thing to kind of go over with the buyer. It kind of spells out exactly what you're going to do, in addition to anything else that you normally have as part of your services. So number 3, buyer representations and duty. So this gets into a discussion with the buyer as far as, look, what your obligation is, right? What your responsibility is when you're working with me as your agent. Number 1, you are going to receive the mandatory disclosure form. So it's going to spell out again that my duties as a buyer's agent, right? And it's going to get into you, buyer. Like, you are going to work exclusively with me. You're going to allow me to negotiate on your behalf. You're going to let me know if you're interested in any properties. If you're going to open houses, you're letting me know. You're working with me. You're going to provide financial information with me, like your pre-approval and things of that nature. You're also going to tell other agents that you are working exclusively with another agent, right? So those are part of your duties and responsibilities. Then underneath here, it says that the buyer understands that this agreement does not relieve buyer of the duty to exercise due diligence for buyer's own protection, including the duty to investigate any information of importance to the buyer. So this is saying, listen, buyer, as an agent, I'm not a home inspector, I'm not an attorney, I'm not a surveyor, I'm not any of these things. I'm not a loan officer, right? So if you have questions that pertain to those things specifically, you need to go get, you need to get that answered by a professional. It's not me. So don't rely on me to give you that information. That's not my forte. That's not what I'm licensed for. So make sure you do your due diligence, and you're not relying on me to do all that stuff for you. All right, so let's get into broker compensation. So we have a couple of options here, but let's start from the top. So we have here, broker's compensation is not fixed, controlled, or recommended by law or by any person or entity not a party to this agreement, and are fully negotiable. In consideration for the services performed under this agreement, buyer agrees to pay broker as follows. Now, you have 3 options. It could either be a service fee. This is where if you're maybe going to take a retainer or something like that, you have the ability to do so, or it could be just a flat amount of whatever, a flat fee. Hourly fee, I believe this is going to go away, but right now it's there. I've never seen a situation where a buyer agent can do that, but it's here, so I guess you can kind of put it together, and I guess you can bill the person at the end if they agree to do that. And then we have Charlie, which is the commission, and this is probably the most typical that we're going to see. So for commission, it reads, in the event buyer or any person acting for or with buyer contracts to purchase, lease, or otherwise acquires an interest in real property that was presented to the buyer by the broker or their agent during the term of this agreement or any extension thereof, buyer will pay broker at the time of closing as follow. So it's either going to be a percentage or a flat fee. Now remember, the maximum you can earn is whatever's on this paper. Whatever number you put there, that's the maximum that you can earn on this transaction. If there are other credits, if there's bonuses from the builder, you are not entitled to that, because the maximum that you can earn is this. Those credits will go to the buyer. Now, in addition to commission, there's some other nuances to it, right? So we have here the commission is due and payable at the time of closing, provided, however, that if the transaction does not close because of any default on the part of the buyer, the commission shall become immediately due and payable. Now, again, this is going to be a broker's decision. In writing, it's, and you might have to have this conversation with the buyer. The buyer reads and says, well, what does that mean? Well, this is what it means, is that if for some reason a deal doesn't close and it's your fault, that we're still entitled to compensation. Now, talk to your broker. Some brokers are like, absolutely not. We're not going to go after the buyer if the deal doesn't close. Some brokers might say, absolutely, right? If it's because of the buyer did something, that weren't supposed to and it killed the deal, we still, we worked, right? We provided a service. We made efforts in putting that deal together. We want to be compensated. Have a conversation with your brokerage. I can tell you right now, eXp Realty, we will not do that. We will not pursue the buyer if the deal falls apart, even if it's their fault. The commission obligation will also apply to purchase or lease agreements executed within blank days after the expiration or other termination of this agreement if the property to be acquired was presented to the buyer during the term of this agreement. This is our protection period clause again, right? So here I would put 90 days. That's usually my standard, 90 to 120 days. So if that buyer comes back to that particular property that you showed, then you're still entitled to compensation. So the broker shall first seek commission, if any, offered by the listing broker or otherwise from the transaction, and buyer agrees but is not required to use the Massachusetts Association of Realtors contract to purchase real estate, whereby buyer may specifically request that the seller pay the broker's commission. All right, so a couple of things here. Number one, if your brokerage is like eXp and you're no longer doing broker-to-broker compensation, you may want to cross that piece out where it says that we're first going to get compensated by the listing broker, and just leave that we are going to try to get compensated from the seller or through the transaction. If obtained, buyer shall receive a credit against any amount owed pursuant to this section. If such commission cannot be obtained from the transaction, buyer agrees to pay broker any outstanding commission due at the time set for closing. Yes, and that's a possibility, right? And you're going to have that conversation with your buyer. And remember, the buyer's in the driver's seat. The buyer's not going to get hit with any surprise fees because it's going to be on the offer. So you're going to know when you're writing up an offer what your compensation is, what you're requesting for the seller, or what what to gain from the transaction. It's going to be spelled out. So if there is a deficiency there, your buyer's going to be aware of it, and then you're going to have a conversation as far as how you're going to proceed. So the broker is prohibited from receiving compensation for brokerage services from any source that exceeds the amount or rate agreed to in this agreement. Broker further agrees not to filter listings based on offers of compensation to buyer brokers. Buyer understands that the seller is not required to pay the broker's compensation. Buyers expressly consent to broker receiving compensation from more than one party. So a couple of things here. Number one, it's stating that you're not going to make more than what you've specified on this agreement. Great. But number two, it gets into steering, right? So it's saying here that, listen, you as the buyer's agent, regardless if another brokerage is expressing that their seller is going to offer compensation, you're not going to use that as a way to filter, right? To present properties to your buyer because they're only offering compensation. That is a form of steering. That is illegal. You cannot do that. Okay. And also, we'll get into the MLS because most MLSs are doing away with the compensation piece. So, buyer agents, it's going to be very common that you're not going to know if the seller is willing to offer a concession. That's what you want to, it's a concession. It's not compensation, it's a concession. So, you can reach out to the other listing agent directly. But again, whatever information you gather as far as concessions, you cannot let that dictate how you're going to show properties to your buyer. That is a legal process that's going to be steering. And then it also states that you can get paid by more than one party, meaning that, let's say the seller is willing to offer to compensate you directly at closing, right? But it's not the full percentage that you were asking for, and there's a deficiency. Well, guess what? You can get paid by the seller and the buyer too, right? The buyer can make up that deficiency at closing. It cannot exceed whatever the maximum amount that you have listed here. And then the last part here just gets into disputes. If there's ever an issue, we're telling the buyer we want you to utilize our services under the Board of Realtors, as far as go through arbitration, all that stuff before you start getting into, going to court and any of that stuff. See if we can resolve that before it has to escalate into anything like that. So under number 5, additional terms. So here it states that, we have authorization to disclose who our buyer is. It also states that, we may be working with other clients that are interested in the same property. Whatever, we discuss is going to be confidential. So if I do show a property, the same property that you're interested in, to somebody else, it's not a break in responsibilities and duties, right? It's not a breach of contract. It's a different person, and whatever we're going to talk about is going to be confidential. Also, we're going to, abide by all, federal and state laws. So under, Chapter 93A, disclose whatever we need to disclose, and, abide by all fair housing guidelines. So page 3, we have consent to designated agency as well as consent to dual agency. So under the consent to designated agency, you're going to write in your name. In that line, it'll be your name. And then the consent to dual agency, it's a conversation as far as how that occurs. Remember, when that is happening, as well as designated, when it's occurring, you do have to give them notice at that time. But right now, you're just getting consent. So number 8 just gets into just finalizing the agreement, stating that, hey, this is a legal binding document. Make sure that you fully understand it before you sign it, because once you do, we're both committed to this agreement. So number 9 is additional provisions. If there's any additional provisions, you would add it here. I think something to consider is, would this agreement be for a geographic location, right? If you're an agent that doesn't like to venture too far of your familiar space, right? Wherever you work, you may say that. You might say, look, this is only for this particular area. If you're outside this area, I'm not helping you. You're welcome to work with somebody else, or maybe you could refer it to an agent in that area. So just something to think about. Then everybody signs off, and you're all set. You have your agreement. Now, if you look at this agreement, against a 3-page document, it's very legal, right? If you look at the verbiage of it as you're discussing with your buyer. So dissect this, right? Simplify it, put it in terms that'll be easy to convey to the buyers, and you'll be okay. But definitely go through it, because if you got a buyer that says, what is this? And you're like, hold on, I got to read it too. It doesn't make you look good, okay? So let me know if you have any questions or concerns with it. Leave a comment or reach out to me directly, no problem. If you don't like this form and you want something that's simpler, reach out to me. I do have some other EXP buyer broker agreements that are much simpler than this, and they can do the same thing. So just reach out and I'll get that over to you. All right, folks, well, listen, happy selling. Until next time.